Heyo, folks. Yes, starting a few minutes early here because I can't pause this Georgia Supreme Court stream. So I have it up and running, and sound is on. I have a booster on, and yeah, now we just have to wait while I go close that door, which I always forget to close. Yeah, what we are waiting for is Attorney Brian Steele arguing to the Georgia Supreme Court regarding Lil Rod's conviction. As you might know, he is serving current life in prison. And if you remember the testimonies a couple of weeks ago regarding that murder that he's serving life for, oh, it was bad. It made me kind of... I want to watch that trial and see how the prosecution acted, because once they got in front of these lawyers in the YSL trial, oh, the witnesses crumbled. I don't know which lawyer Lil Rod had back then, but whatever lawyer he had did not do a good job. Hello, folks. Hello, folks. Mrs. Perfect Timing. Hello. Gigi. Hello. Fatima. JOK. Stephen. Denise. Christine. Erin. Kristen. Sioya. Now I'm shutting up, because they are about to talk. Tell me if the sound is good, too high, or too low.
All rise. The Honorable Supreme Court of Georgia is now in session. Chief Justice Michael P. Boggs presiding.
Ooh. Georgia Supreme Court. Oh, I need to move this one. Yeah, this is Brian Steele. Brian Steele is going to argue Lil Rod's conviction towards the Georgia Supreme Court. And now I'm shutting up.
Good morning, everyone. I'm Interim Dean Courtney Anderson on behalf of this faculty, staff, and students here at Georgia State University College of Law. It is our distinct honor to welcome the Supreme Court justices to our community. Each year, we are privileged to have the justices administer professionalism oaths, serve on our advisory boards, speak to student organizations, and now hold court at our institution. The College of Law's mission is to promote an innovative, equitable, and inclusive vision of the law through high-quality, accessible education, impactful research, and service to our communities. The opportunity to witness oral arguments in our space elevates what we teach in the classroom to see advocacy in this profession that we value, and that is the foundation of this republic. Thank you so much to the Supreme Court staff and to the attorneys and their teams for providing an incredible experience in service of our mission and making this day, November 5th, more eventful than anticipated. Thank you again, and I'll now turn it over to Chief Justice Boggs.
Well, thank you and good morning, everyone. We're honored to be with you. Interim Dean Anderson, thank you for the warm welcome and for hosting us today at the College of Law. I'd also like to thank members of the GSU planning team who worked hard behind the scenes to set up this special session. There's a lot of work that goes into this, as you might imagine. So I'd like to thank Associate Dean Tamika Lester, Christine Thomas, Travis Chambers, Natasha Peters, Jaja Franklin, Emily Harden, and Sergeant Wes Patton and the GSU Police Department. Thank you all for what you've done to accommodate us here today. In addition, I want to acknowledge and thank all of the professors, administrators, staff, and students who are here this morning to observe the work of their Supreme Court. We always look forward to holding these special sessions off-site at different locations around the state, including at law schools outside of our courtroom, and really in hopes that today's session will provide an opportunity for you all and others that are unable to maybe get to the Supreme Court building to better understand the work that we do. While this is not our court's first time at Georgia State's College of Law, it is the first time for many of us on the current bench. I believe that the last time our court was here for oral arguments was in 2016, shortly after this building opened. And I have to mention how heartening it is to see the faces of so many people who are keenly interested in being a part of and hopefully improving the practice of law here in Georgia. I'm now, as tradition is when we go off site, going to briefly introduce my colleagues up here on the bench. I'm going to do this in seniority order. And so I begin with presiding Justice Nels Peterson to my right. Justice Peterson has a BS in political science from Kennesaw State, was very proud of the Owls' recent win over Liberty. Was also SGA president at Kennesaw State. He went to law school and graduated with a JD from Harvard Law School, formerly served as executive counsel to Governor Sonny Perdue, was the state's first Solicitor General in the Attorney General's office, served with me and others on the Georgia Court of Appeals, and is from Cobb County. So that's Justice Peterson. Next to my left, Justice Sarah Warren, who is a Duke University undergrad in public policy and Spanish major, and also Duke magna cum laude School of Law. Double Duke is what I think they're called, which doesn't make any sense to me. She was served as Deputy Press Secretary for the White House Office of Management and Budget. She was in private practice at Kirkland and Ellis in DC, was the state's third Solicitor General in the Attorney General's office, and she and her family live here in Atlanta. So welcome to Justice Warren. Next, Justice Charlie Bethel, a double dog, business degree and law degrees, both from the University of Georgia, former state senator from Dalton. He and I served together in the legislature. He also served on the Court of Appeals, and he and his family live in Dalton, which is in Whitfield County, just north of here in North Georgia. So that's Justice Bethel. Next to my left is Justice John Ellington, another double dog with accounting degree and law degrees from the University of Georgia. He served in multiple levels of state court, serving both on the all on the Court of Appeals and by designation on the Superior Court of the 5 judicial circuits throughout South Georgia. He also served as a municipal court judge in Soperton. He's from Soperton, as an avid, I should say, dog fan, also a turkey hunter, somewhat of a Renaissance man, bakes pies, makes ice cream, and has a green thumb. So, Justice Carla Wong McMillan to my right and your left earned her JD from UGA and her bachelor's degree in history and economics from Duke. She's the first Asian Pacific American appointed to our court. Previously, she and I and others served on the Georgia Court of Appeals together, and she's formerly also a trial court judge, having served as a state court judge in Fayette County. She was born and raised in Augusta, but resides with her family in Fayette County. Justice McMillan. Next to my left and your right, one of your own, Justice Sean Ellen LaGrua, who graduated from here with her JD and undergrad from University of Georgia. Previously served as Inspector General for the Georgia Secretary of State. She served as Solicitor General, prosecutor for DeKalb County. Before joining the Supreme Court, she was a Superior Court judge here in the Atlanta Judicial Circuit. I know you're all proud, as we are, to come back to her alma mater and be at her school where she graduated from law school. So welcome to Justice LaGrua. Next to my right and to your left at the end of the bench is Justice Berta Colvin. Justice Colvin is a UGA law and a Sweetbriar College undergrad. She is a former Assistant United States Attorney in the Middle District of Georgia. Before that, she was Assistant Solicitor in Athens, Clark County. After that, she served as a Superior Court judge in the Macon Judicial Circuit. She likewise served on Georgia's Intermediate Appellate Court, the Georgia Court of Appeals, and she and her family live in Macon, Georgia. Justice Colvin. Next, to your right and my left, Justice Andrew Pinson, the newest member of our court. He's our third double dog. He has a finance degree and law degree from the University of Georgia. Previously, he likewise served as a Solicitor General, just like Justices Peterson and Warren at the Georgia Attorney General's office. He likewise served on Georgia's Intermediate Appellate Court on the Georgia Court of Appeals. He was born in DeKalb County, and he moved to nearby, about an hour northwest, Lincoln County during middle school. And we enjoy Justice Pinson's service on this court. I know you want to welcome him as well. So that's Justice Pinson. Finally, myself, I have an undergraduate degree from Georgia Southern and with a degree in political science and psychology. I played football at Georgia Tech for a moment on scholarship until being injured. I have a JD degree from Mercer University School of Law. I formerly served in the legislature, formerly served as a Superior Court judge in the 6 counties of the Waycross Judicial Circuit. After that, I was on the Georgia Court of Appeals for a while, and then continued my appellate service on this court. I'm from Ware County, which is Waycross, Georgia. Any of you don't know where that is, 250 miles south of here. You would think you would be in Florida, but you would be wrong. You would still be in Georgia, and you would be in Ware County. I currently live in Pierce County with my spouse, who is a kindergarten teacher in the Ware County public school system. So with that and those introductions, I always enjoy doing that. I sometimes remember things I had forgotten about my colleagues. I hope you can see the breadth of experiential diversity and other diversity on this court. I really enjoy my colleagues. They're an honor to work with, and I think you'll understand that as we go through today's process. Next, we will move to the next item in our category of agenda items, which is the admission ceremony. Madam Clerk, do we have any requests for admission for new members to the bar of the Supreme Court of Georgia?
Yes, Your Honor, the following named applicants have properly certified applications, and I respectfully move for their admission to the bar of the Supreme Court of Georgia.
When your name is called, please come up the stairs onto the stage and stand in front of the bench, if you will. So I presume we want that right.
I can't pause this. So we are live and it's going on, and it's
Marilyn DeWint,
apparently
Jones,
some admission ceremony going on.
Good morning. If y'all will stretch out right here in front of the bench so we can get a good look at you. Don't be nervous. Some of the lawyers might be, but you don't need to be nervous. Welcome. It's my honor to administer the oath to you. If you will all please raise your right hand and listen to this oath. You do solemnly swear or affirm that you will conduct yourself as an attorney or counselor of this court, truly and honestly, justly and uprightly and according to law, and that you will support the Constitution of the state of Georgia and the Constitution of the United States. So help you God. If you agree with that oath, please say I do. And you can put your hands down. It's a tradition at our court that when we admit new lawyers to practice before the Supreme Court of Georgia, one of our members gives welcoming comments. You would not be surprised to know who that's going to be today. It is not me or the rest of my colleagues to my right, but rather a Georgia State University College of Law graduate and my colleague, Justice Sean LaGrua. So Justice LaGrua, I'll turn it over to you at this time.
Thank you, Chief, for that opportunity. Good morning, everyone. And Dean Anderson and the rest of the Georgia State family, thank you so much for having us here this morning. It's an honor for me to give opening remarks here at the law school that I attended, sort of. It didn't look anything like this when I and my classmate, colleague, and very dear friend, Judge Joe Burford, attended law school. We were in the Urban Life building with 3 classrooms, no cafeteria, and it wasn't nearly as clean and as pretty. I was trying to think about what to say this morning, and knowing it would be election day made me think I would be remiss not to recognize that. Today is a historic day for you and the country, though I really think every election day is a historic day. It is the day that our collective voices choose how we will be governed. George W. Bush said, "We vote not because we're liberal or conservative, but because we're American citizens, and that's our responsibility." As lawyers, you are the ultimate embodiment of civil discourse that unfortunately has been lacking often in our country as of late. I remember having 2 conversations shortly after I came to this bench with 2 friends and colleagues and lawyers that at the time I did not know knew each other. Both had served in the legislature. We were discussing the fact that there was a time where we could respectfully disagree with one another and not be viewed as evil. They both recalled how they would disagree on the floor of the legislature, walk out of those chambers, pat each other on the back, and ask, "Where are we going to dinner?" I remember how refreshing that attitude was. As lawyers, you are the ultimate embodiment of civil discourse. You have the opportunity to treat your colleagues on the other side of the aisle with the same respect and cordiality that you would want to be treated with. The public looks to lawyers as examples and often turn to you at election time to help educate them about the process. As Franklin Delano Roosevelt said, let us never forget that government is ourselves and not an alien power over us. The ultimate rules of our democracy are not a president and senators and congressmen and government officials, but the voters of this country. As lawyers, you will often be looked to as knowledgeable leaders, and there are two critical things you can do to be role models for young lawyers, associates, and the community as a whole. One is be the leading example of cordial discourse in our communities. Think about how much more enjoyable your work will be if you enjoyed working with the lawyers on the other side. A good friend, another classmate of mine from Georgia State Law School, Carrie Christie, starts every case she gets with a call to opposing counsel saying, "Hi, this is Carrie Christie. Looks like we've got a case together. How can I help you get us started?" Secondly is something near and dear to Chief Justice Boggs, Justice Colvin, the chair of our Access to Justice Committee, and all of my colleagues here on the bench. We have a large part of this state considered to be legal deserts. That is, places that don't have enough or any lawyers, but do have indigent people that need representation. Commit today, going forward, to help out. Take on a pro bono client each year that doesn't have access to justice because of their financial situation or because of where they live. Not only will you be giving back, but being a great role model for your kids and your colleagues, but you will find it makes you feel good. In the words of Martin Luther King Jr., our lives begin to end the day we become silent about things that matter. Unfortunately, that is too true for some of these folks. Please be their voice. Finally, congratulations. And in the words of my dear friend and colleague, Justice John Ellington, get a life outside the law. It will make you a better lawyer. He would also say very emphatically, I would guess, go Dogs and Panthers.
And thank you, Justice LaGrua. I always appreciate hearing from my colleagues and the things that they lift up as important to them and to the bench and to the rule of law in Georgia. Echoing concerns about professionalism among your profession that you've chosen, the obligations you all have to give back by being role models is something that I'm very proud that Justice LaGrua has raised. And also the obligation you have to give to others less fortunate and who are in need. We don't have civil Gideon in Georgia. You understand what that means. And you understand that there are at least 7 counties in Georgia that have no lawyers. You know, I say that in a room with some folks and they think that's a good thing. There are 57 counties in Georgia that have 10 or fewer. And so I remind all of you in echoing the comments of Justice LaGrua that serving others through pro bono service and otherwise is critical to helping people in their most significant and crucial times in their lives. So what you can do to help there would further the profession. And to me, it helps build confidence and public trust in the judicial system. So with that, I thank you, Justice LaGrua, for your remarks. You will now proceed out the way you came in and follow the deputy clerk to sign the roll of all lawyers in Georgia that have been admitted to practice before this court since 1845. And you'll get an opportunity to do that. And for a nominal fee, you will be given a certificate commemorating this occasion and notifying others that you are admitted to practice before this court. And we say that for that nominal fee, that certificate is worthy of framing. So we hope you will do that and display it proudly. Thank you all for being with us today. We look forward to seeing you back at the court. Thank you. During today's session, we will hear arguments in two cases. In both of those cases, each side will have 20 minutes for argument. If the opening argument does not last for the full 20 minutes, the remaining time may be used for rebuttal. We remind counsel they're not required to use all of their time, as sometimes less time and shorter arguments are more effective. You will note, as in our courtroom, the courtroom clocks are located where you can see those. When the yellow light appears, we remind counsel you will have 5 minutes to complete your argument. When the bell sounds, we would respectfully ask you to wrap up your argument as your time has expired. With that, Madam Clerk, will you please call today's first case?
Yes, Your Honor. S24A 1303, Damone Blalock versus the state, Brian Steele for appellant, Alex Burnick for appellee.
Okay, he's arguing for Blalock. I need to change
Good
the.
morning, Mr. Steele. Good morning,
Heather.
Mr. Burnick. Once you get yourself settled, Mr. Steele, you may proceed when you're ready.
Good morning. May it please this honorable court, my name is Brian Steele, and I represent Appellant. On May 24th of 2019, Appellant was indicted for participation in criminal street gang activity, malice murder, 3 counts of felony murder, 3 counts of aggravated assault, criminal damage to property, possession of a firearm during the commission of a crime by the Fulton County Grand Jury. Appellant went to trial with other counsel, and the count 1, which is the gang count, was severed or bifurcated. So that did not go to this jury. On September 30th of 2021, Appellant was convicted of all of the counts of the indictment that went to trial. He is currently serving life in prison plus 25 years, and that's all at record page 7 through 14 and 354 through 356. Appellant has raised 4 enumerations of error. The last one is cumulative error under State versus Lane. Unless this honorable court directs me otherwise, I'd like to discuss the first enumeration of error, which deals with a witness being sworn and on most of the questions invoking her Fifth Amendment right not to answer the question. The facts are very simple. They're tragic. There's loss of life here and destruction of lives throughout. It is 3 gentlemen are in a car. Not that it matters, the car was stolen that day in Cobb County. They drive to Fulton County. They come here because they're speaking with a woman named Miss Hartfield. Ms. Hartfield explains to the gentleman that if they come to Atlanta area in Fulton County, they will be able to get high with girls and have sex. The 3 men come, they pull up. It is early morning hours, and Ms. Hartfield and another young lady named Miss Smith are in the car with the gentleman. Ms. Smith exits the car purportedly to get the marijuana. Ms. Hartfield actually did that. Ms. Hartfield comes back a moment later, asks Ms. Smith to come with her. As soon as Ms. Hartfield and Ms. Smith were away from the car, gunfire erupted. The car was riddled with bullets. The front passenger was fatally wounded. The driver tried to leave. The car was disabled. The driver and the rear passenger flee. And Ms. Hartfield is on the phone later, and it's videoed. It was a FaceTime call, and it's videoed by a different person, a witness named Mr. Bell, and is being asked by one of the surviving witnesses, did you set us up? The law enforcement gets the information, and they find and take in that night Miss Smith. She tells law enforcement, I don't know what you're talking about. I have no idea what this is about. Eventually, after 2 hours, she is confronted by law enforcement. They're very sophisticated, very accomplished homicide detective with City of Atlanta. And she then implicates Appellant, the co-indictee, and Ms. Smith. Ms. Smith tells law enforcement, I don't know what you're talking about. Pursuant to Instagram messages that the trial court allowed into evidence, it was identified as Appellant and the co-indictee speaking with Ms. Hartfield, and Ms. Hartfield explained that Ms. Smith snitched, told appellant's name, gave Ms. Hartfield's name, and appellant responded, "I knew that she's a rat, and what did she say about me?" Those are not the exact quotes, but that's the way it came out.
But that sets up the facts for what is an IAC claim around her invoking her fifth. Is that right?
Yes.
Can you articulate for the court the nature of the IAC claim? And for me, I'm interested in the prejudice side of it as well.
Okay. So Ms. Hartfield is going to be a witness. She's in custody at the time of trial. She announces she has her own independent lawyer. Her lawyer announces to the trial court that her client will not be testifying. And she does that properly. Everybody agrees it's proper because Ms. Smith is potentially set up this murder. She was close to the murder. She's on the phone afterwards with the supposed killers, the co-indictee and appellant. She lies to law enforcement allegedly about she wasn't there.
Was there any indication that Ms. Hartfield was going to testify about anything?
She did testify to things that were not germane to appellant's trial. But yeah, she answered that she
What
knew.
about the threats? Those weren't germane? The fact that she said she was threatened to not talk, or maybe someone said they were going to kill her?
Yeah, so that came out that the victims, the living victims, that their friends, family, supporters, gang members, whomever, were threatening Ms. Hartfield because she supposedly set up the death of the deceased.
So counsel, let's contextualize what we're doing. There's no question, at least in my mind, that the procedure in the trial court, the best practices for a witness invoking the Fifth Amendment were not followed. I mean, the precedent sort of lays out, this is the best way to handle a witness who is going to invoke their Fifth Amendment rights. We don't really like that happening in front of the jury. That's not sort of the best practice of how to handle it. But it doesn't require that, right? I mean, in other words, the precedent that says this is sort of the best way to do it doesn't say it's the only way to do it.
This was pretty much the worst way to do it, but yes, I agree with you.
So because you're coming in through ineffective assistance of counsel, you have to demonstrate that no reasonable lawyer would have considered this to be beneficial to their case. And while I understand, but I was going to say it because you're bound by your prejudice arguments. Independent of that, your argument is, hey, look, there's not overwhelming evidence of guilt here. Assuming I don't accept that the other evidence that was coming in was pretty damning for Mr. Blalock. I mean, you sort of got the sequence of he's there, he's identified as running and shooting at the scene, and then you have the after the fact. And I understand that it could be construed another way, but saying I knew that she was a rat, all those sorts of, that's pretty bad evidence. And it's really sort of for the jury tough to hear those things. Why is it not possibly a reasonable strategy, something that a reasonable lawyer could do, to say, hey, watching this witness take the Fifth over and over again, when my strategy is create as much confusion and possible reasonable doubt, in other words, it might benefit my client. Why is that not a reason? Why could no reasonable lawyer have thought that?
For three reasons. First of all, this trial lawyer, who's a wonderful lawyer and she's learning, she never tried a case like this at all. She tried.
But I'm not judging what she thought, right? It's an objective standard. It's not whether she had a good strategy. The question is whether any reasonable lawyer could have done what she did.
No reasonable lawyer would have done this. What happened was the prosecutor asked the following sets of questions that are germane. They're talking about February 23rd, 2019. Was Ms. Hartfield with Ms. Smith, the other person that we mentioned? Fifth Amendment. Was she in the area where the shooting occurred? Fifth Amendment. Was she with Appellant that day? Fifth Amendment. Was she with the co-indictee that day? Fifth Amendment. Did she communicate with Appellant on Instagram? Fifth Amendment. Did she arrange for the victims to get shot? Fifth Amendment. Did she enter the blue Charger, the car of the victim?
Why does that not
Fifth
just let the jury infer that it's her fault and not appellant's fault, and this shift blame away from appellant to her?
That never happened. The only question she did answer,
No, but why wasn't the jury authorized to infer that?
because that would be unreasonable. She's
Well-
invoking the Fifth Amendment. Did I interrupt you?
No, thank you. But I mean, it's to say it's unreasonable. I mean, one juror might think that's unreasonable. One juror might think it's reasonable. We let jurors make those kinds of differences.
Wasn't the argument articulated that she was covering for herself and others?
No, I mean, that really never came. That's the prosecutor saying. The evidence, the argument was that there's not enough evidence to prove that appellant was there. That was her defense. And said, listen to these witnesses. The facts are not overwhelming, respectfully. Ms. Smith, who did identify appellant as a shooter, she gave total inconsistent statements. She was in the car and she was impeached thoroughly. The Instagram messages are what I explained. They're not so overwhelming to me. I mean, when you cross-examined, which you couldn't on this because Ms. Hartfield wouldn't allow the cross-examination, that was not that bad of evidence. And nobody would agree that this is a good strategy. I don't believe no objective basis to believe that a reasonable lawyer would think, yes, let Ms. Smith handle the testimony and get confused. There's no confusion here. Ms. Smith did answer the questions on cross-examination by appellant's lawyer. Did she set up the victim? She said no. And did she direct appellant and co-indictee to do the shooting? She said no.
But you also said she's been impeached so many times, the jury would have been authorized to believe or disbelieve any of these answers, given how often she was impeached.
How was she impeached? She invoked the Fifth.
You said she was impeached.
That's Ms. Smith.
Oh, I'm sorry.
The Honorable Justice Bethel said, potentially this is overwhelming evidence. There's an eyewitness. That eyewitness is I wouldn't want to call that eyewitness.
Isn't it possible that the counsel was trying to throw out red herrings to possibly have the jury think, well, we don't know what happened or who was responsible?
Counsel didn't even respectfully know that she could object to this procedure.
She not only didn't object, she helped craft the instruction.
That's the worst part.
And and I'm gonna let you respond to that. Back to the strategy and what a reasonable lawyer might do. Did I misunderstand that maybe Hartfield's counsel, the trial counsel, Blalock's counsel at trial, in closing argued that this witness, Hartfield, was using the privilege to shield whomever she was protecting, and that she really set everything in motion and she was protecting the real killers whom she was trying to shield. I mean, was that the argument made by Blalock's lawyer at trial relative to her testimony?
That's a closing argument after the trial is broken, and this is how it comes out. There's no reason to put up Ms. Hartfield and allow her to invoke the Fifth Amendment. The lawyer didn't know about it. The problem we have here, really, that's bad. I think that's bad. But you want to talk about reasonableness and objectively under the Strickland standard. How about the jury instruction? At the very end, the jurors are now deliberating. And they ask, how can we use this Fifth Amendment invocation? And with the help, non-objection, and consent of appellant's lawyer, the court said, and there's more to it, this is a transcript of volume 11, 1465, line 8 through the next page, line 1. The trial court said that our Constitution guarantees that individuals cannot be compelled by the government to provide incriminating information about herself, the so-called right to remain silent. When an individual takes the Fifth, she invokes the right and refuses to answer questions or provide information that might incriminate her about this case or other. This is the part that I'm stressing. Now, this concept factors into your fact-finding and ultimate how this concept factors into your fact-finding and ultimate decision is for you to decide. And this court has explained over and over, we are going back decades, that when a witness invokes their Fifth Amendment, that cannot benefit or be to the detriment of any of the parties. That's why I have a problem with this. And that's why when it combined, you can't just look at it to me in isolation. That's why without knowing the law, you can prevent the witness from testifying and then couple that to tell the jurors, you can use this in your deliberations.
Well, that
as
helps
a-
you on deficiency, but we still have the question of prejudice.
The prejudice, this, this court has seen more cases than I have ever seen. But I've tried a lot of cases. This is not an overwhelming evidence case, respectfully. I mean, you are the judge, you make better determinations, but to have an eyewitness that lies to the police immediately, that explains that she changes her story, even at trial, she gets impeached with different versions of her story. She's in a car where people are now dead and she doesn't get charged. These are factors jurors take into consideration.
Mr. Steele, I think I understand your position on the strength of the overall evidence. Can you articulate the particular harm of this sort of colloquy in stating the fifth that you say sort of impacts the prejudice inquiry? Why was it so prejudicial, and why does that sort of tip the balance?
Because we know the jurors were interested in it. The jurors sent out a note during their deliberations asking how they can use it. They were given an erroneous instruction. And under our law, they should never have been allowed to use against appellant potentially the fact that were you with
And
appellant?
why was it likely that the way that this went down through the trial, that it would be used against the appellant rather than sort of in some other way?
It couldn't be any other way. The witness, Ms. Hartfield, said, I'm not involved in the shooting. I didn't direct the shooting. Were you with appellant? I'm not going to answer that question.
Well, while we still have a couple minutes left, could we pivot to another one of your enumerations? The second enumeration, the burden shifting and the comment on silence. I am troubled, particularly on the comment on silence aspect, but because it is brought through, and I intend to ask the state about that during their time, but because it's raised through the lens of ineffective assistance, again, that requires a showing of prejudice. What is the prejudice from the comments on silence, particularly when one of them, there was an objection made and the objection was sustained and the jury was told to disregard that one particular sentence?
Jury was told to disregard, I think it's 5 words of a sentence. They were not told to disregard that entire argument by the prosecution. Telling a prosecutor, to me, as a reader, knowingly commenting on the accused right to remain silent is well beyond what we're doing here.
In terms of deficiency, I think that's a strong argument, and which is why I'm taking you straight to prejudice.
And to say to the jury, I want to know, I need to know, the quote is, if they were not committing the murder, where were they? And then if you read out the part that the trial court struck, if you disregard that, it reads like this. If they weren't committing the murders, where were they? They are both saying it wasn't, they weren't there. We didn't hear any evidence of it, obviously, but I would still like to hear that answer. And it's clear it's talking about where were they?
Well, the sentence before that, or the words before, we didn't hear any evidence of it, was preceded by, tell us where you were, implying that they had an obligation to not be silent, but rather defend where they were.
So I don't believe that the instruction was proper enough, go far enough, but your court always taught me that generally jurors who are sworn are bound to follow the court's instructions. And the court said, I'll sustain the objection, tell us where they were should be disregarded. So I read it out. That's why I did that.
Do you, counsel, do you think that Lampley, where we said, quote, you may not have every question answered because the only person that can answer all of your questions is the defendant sitting there at the table, was permissible? Do we need to overrule Lampley for you to win on this point, or can you distinguish that? I mean, is Lampley right, I guess is one question, but can you distinguish from that comment?
Well, respectfully, I don't think Lampley's great writing from the court, respectfully. I mean, respectfully. But I don't think you need to overrule
It does happen.
Not often, but I don't think that it needs to be overruled, because in context, the prosecutor here was clearly going at the fact that Appellant did not testify. The appellant did not put in this evidence. There is no way around it. The lawyer, the prosecutor, was so prepared on his objection the first time by saying, no, Your Honor, it's not objectionable because I prefaced it. I surrounded with there's no burden of proof on the prosecution.
But Mr. Steele, there were objections here. So what is the ineffective assistance where you say, I mean, is there a piece of this that was not objected to that is the focus of this argument, or?
The only objection was burden shifting, and I thought this court taught that the objection should have been commenting on the silence. That's why I raised it. I don't believe that it is. There's an objection. You just have to be honest with everybody.
And so the
There's an
ineffective
objection.
assistance claim is not the lack of an objection, but an objection with the wrong explanation for it?
Your court teaches that you have to make a specific, proper objection. I believe, if I'm wrong, then that's me on habeas, but I believe that the objection should have been the comments on the right to remain silent. So-
Counsel, let me ask, if the court excluded, tell us where you were, outside of that statement, how is it wrong for the prosecution to say there's no evidence?
Not what the prosecutor said. Prosecutor said, I would still like to hear that answer. It is still going to the fact that the appellant did not make that claim.
But is that directly enough to win your argument?
I hope so. I will find out.
Good answer.
Mr. Steele, that's a good way to conclude. Thank you for your argument.
Thank you so much.
Appreciate you. Thank you. Vernon, good morning.
If it may please the court, my name is Alex Bernick, and I represent the state of Georgia on behalf of the Fulton County District Attorney's Office. I'm gonna go ahead and jump in right into enumeration 1 here. That's one we spent most time on.
So if, with your apologies, could we pick up where we left off there?
Of course.
And help me understand why this comment on silence, which is you would agree that it's a different point than burden shifting.
Right.
Why that's not a problem to say, I would like to hear this answer. Why? You're going to tell me in a minute on prejudice that you had overwhelming evidence of guilt. Then why does a prosecutor need to stand up in front of a jury and play games with constitutional rights?
Well, I think this comes back to this court's, as I cited back in my brief to Ridley. Ridley states that what a defense.
Other than Lampley, none of the cases you cited apply to something like this. Ridley and Thompson, and I think it was Johnson or Jackson. They're all cases either about the defense's failure to offer other evidence. For example, defense lawyer says, all these other witnesses who didn't testify would have exonerated me. State stands up and says, you didn't even subpoena them. State offers lots of circumstantial evidence. Defense lawyer doesn't rebut the circumstantial evidence or explain it. Defense lawyer or prosecutor stands up and says, they didn't explain away that evidence. That's very different from the defendant didn't tell you something important. Evidence coming from the defendant as opposed to explained or argued by the defense lawyer is a very different thing when it comes to right to remain silent. In our case law, the only case that I see that gets close to that is Lampley. And the statement there was really in context more of a throwaway than a principal point that was repeated through multiple sentences.
I'll disagree with you on that one. I think when you look at the closing argument in total, you'll see that this is a comment about defense attorneys' inability to explain away or present evidence on their behalf. And as in Ridley,
in context, it's pretty clearly a comment on the defendant's failure to answer the question where he was.
Well, I think when we go back to the second closing, that's where we come back when the prosecutor begins the second closing. He explicitly references the attorney's argument there. He explicitly references, did you hear in the attorney's argument that there was any failure to explain? It wasn't about the choice to testify. It wasn't about whether the defendant testified here. It was clearly throughout it, it was with expressed to the defense attorney's argument and failure to rebut the evidence, which is in Georgia law has been accepted that you can do. And
I know I sidetracked you on the enumeration too. If you
Go
want
ahead. No,
to do the
ahead.
Fifth Amendment thing, that's fine.
if you need me to address prejudice here.
We may come back to it. I mean, prejudice is going to be the same for all of the first three enumerations unless we get to cumulative. So if you want to talk about your evidence, you certainly can, but I think we're familiar with what the jury heard.
I'll go back. I'll just go ahead and go to enumeration 1 then, with the text messages. Excuse me, text messages, got the wrong one. Fifth Amendment. This is clearly trial strategy here. It's clear trial strategy. It's a coherent trial strategy. You see it in opening. The defense attorney asked why the two women were not at the table, and that the defendants were scapegoats. They were hiding something. Closing argument. The attorney comes back around and says, Mariah Smith and Hartfield are the ones who set this in motion. Why are they not here? And then we come back to the motion of trial where she testifies and she says, part of my strategy is to put the blame on them, ask why they were not there, and argue that the privilege was being used as a shield for him.
But how does that map on to the jury instruction? Because the jury instruction then seems to undermine that to some extent.
I don't think it does. I think the jury instruction complements trial strategy here. It allows them to build in this inference that, and while inferences are not allowed, it does allow her to build and argue that.
So it was good because it allowed something that's not allowed?
It can be.
Inferences of her guilt are allowed.
Inferences of her guilt are allowed.
Yeah.
Right.
But can you explain how that addition to the jury instruction is supposed to be understood by the jury consistent with the Constitution?
On its face, it's more likely that it's not consistent with the Constitution, but we're here in an ineffective assistance realm, and so with trial.
Are you conceding there was deficiency?
I'm not conceding because
Okay.
I
I mean, because I think if you're, I get what your point is. It's not, the question is not simply, was this jury instruction right? But at the end of the day, if what you're saying is no, actually, that would be really hard for a jury to understand consistent with the Constitution, then I think.
But erroneous jury instructions are not necessarily per se deficient performance.
They're not necessarily, but it can make it. I mean, it really then points us to prejudice.
Right.
So what is your best formulation of that argument, that there is none?
There is none. I think we go back to Horn on this case, and Horn is very similar, and that was a direct review case. Horn asked whether there was any evidence of material facts that were added from the leading questions. It's very similar to cumulative evidence in a prejudice in an ineffective assistance of counsel. And here I would say there was no material facts that were added, either as to appellant's guilt. If you were going to add any facts, any obvious inferences that were made, it was that she was a co-conspirator, and that's obvious from the evidence that was already introduced and independently introduced of this. Also, we do have strong evidence that was noted by the trial court, who's in this position to make that finding. They're the ones who saw the trial develop. They were ones who also were able to just address credibility and weigh that evidence just as a juror would.
But counsel, how can you say that there was no inference that the appellant was guilty when she took the fifth on questions like, were you with him on that day? Do you know him? I mean, all those kinds of things where, I mean, wouldn't the inference, if the jury believes she was taking the fifth to hide something, she was hiding the fact that she knew him and that he was there at the scene on that day. So why would that not be an inference of guilt against Blalock?
Well, I think we come back also to her cross-examination testimony that she gave there. She denied setting them up. She denied directing Blalock or Ryan to shoot them. And so between the inference that could be created, as you suggested, and
Well, trial counsel argued she was protecting the real killers.
Right.
Obviously, it wasn't Blalock, somebody else.
Someone else. And honestly, she also took the fifth to saying that she had a gun that day, or she shot him. So you could also build that.
But is that a reasonable inference to draw? I mean, when the question is, were you with this defendant during the murder? And the answer is, I'm going to assert my Fifth Amendment right to avoid self-incrimination. No, I was not with him is not incriminating to her. The only answer that's possibly incriminating is yes, which then ties him. I mean, isn't that sort of by a wide margin the most reasonable inference to draw from that invocation?
I don't think so necessarily. I think it creates the gray area that she wanted to bring up. She wanted to hide the real killers. It's a gray area that she wanted to operate in, is to create this reasonable doubt, create that there's someone else out there that was in there. And I think she wanted to create that, and that ties into the trial strategy.
How does not answering the question of were you with this defendant during the murder doing that?
Well, it was, I think the question was, were you with the defendant that day, not necessarily during the murder? And so that day is broader than the murder, than the time
What
of the
else
murder.
could she, what else could be incriminating that happened that she wouldn't be able to answer about? You see, like it seems like if she's invoking,
Mhm.
then there's something she's worried about that's incriminating to her, which then leads to the inference that the presiding justice was suggesting.
Or could it be the inference of other prosecution activities that they had earlier in the day?
It could be a prosecution, other prosecution, the marijuana deal, the drug deal that she set up. Could be that.
But there's not part and parcel of what ultimately culminated in the murder.
They were, but not necessarily part of what was charged with the appellant.
But,
here.
but I mean, if that's all they'd been involved with, and then there was a murder, you would have charged that as party to the crime, and we'd be here arguing about that. So, I mean, I don't see how that's really how that's potentially bringing in third parties through this inference. And the other problem is, if this was Jackson's sufficiency, we would say, well, it was a conceivable inference that could have been drawn, and we allow juries to do that. But this isn't Jackson's sufficiency. This is Strickland prejudice, and we look to what inferences are reasonable and likely.
Well, Lawrence also says that it's obvious inferences there, and so I don't know if it's necessarily obvious that that Blalock was with her during the time of the shooting. It could be reasonable to infer, but not necessarily obvious.
Seems like it's a pretty reasonable, unreasonable stretch to draw that inference. I don't disagree with the question from the presiding justice. My question is, though, did counsel argue at closing the third party inference that the jury was supposed to draw from the invocation?
No, she did not, and she just argued with respect to Hartfield was that, Mariah Smith and Hartfield clearly set this in motion. She focused more on Smith's testimony and the location of the bullets and ballistics.
Which makes the inference you rely on even more difficult.
I think
it's not reasonable. If it's reasonable trial strategy, you would have presumed that the lawyer would have argued it in closing.
She would have, but she also, it ties into this argument here, this sentence here.
I mean, do we assess deficiency and prejudice in slices like that, or do we look at it in the context of the whole case? The question is not, could any reasonable lawyer have done this one discrete thing in the abstract? The question is, could any reasonable lawyer, and it is an objective standard, have done this thing in this particular context of the whole case, right?
Right.
Okay.
I think it's to the whole case, and we also see that this argument doesn't apply just to that they were lying, they were hiding. It doesn't apply just to Hartfield herself, but also applies to Mariah Smith. And so I think if you had it just applied to Hartfield herself, you'd have a bigger issue. But because it's Mariah Smith, you showed this trial strategy has been crafted about the whole case itself.
So I apologize, excuse me, if I missed this, but I'm not sure I've heard a prejudice argument from you that talks about, that assesses the strength of the evidence overall.
Okay.
Could you provide that argument?
Yes. Mariah Smith was eyewitness here. She identified Appellant shooting and shooting into the vehicle. I think the most corroborating circumstantial evidence is that we have those text messages that were sent, I guess Instagram messages were sent shortly after Mariah Smith and Hartfield had been picked up by law enforcement, interviewed by them.
Were those Instagram messages admitted? I thought there were some problems.
They were admitted. And actually, they were raised on motion to trial, and they were not raised here in the Supreme Court. But they were admitted of objection. And those Instagram messages talk about why else would Blalock be interested in someone being picked up and snitching on him in a closely related time, and also knowing that she was a rat. So it's implied guilt there, implied.
I mean, that, so sort of by your own phrasing, you're admitting these are circumstantial pieces of evidence. Sometimes it's hard to get to overwhelming evidence by just circumstantial evidence. Is there anything else?
But you can. There's also the text messages that place Hartfield and Blalock and Ryan at the scene close in time. We know that both Mitchell and both Mitchell and Hartfield were texting between the two. And Mitchell and Uten's story, even though they didn't identify Blalock, they largely corroborate her narrative of what occurred that night also.
And their description of the shooter is reasonably consistent with the physical appearance, although they couldn't identify anybody,
Right.
right? So let me ask this. So basically you've got evidence that the four were together, the two men and the two women. They split up and the two women joined the three victims for lack of, I mean, the three folks that were in the car when the shooting started. And then they moved to a new location. Women got out of the car in what appears to be a coordinated fashion, if we're taking the evidence in your way, and then shooting broke out. Right. And then after the shooting, there's this flurry of messages between the women and some of the victims and the women and the appellant, right?
Right.
And so when the appellant responds, I knew this person was a rat, is the only inference of that I was guilty, or could it be I was double crossed? There was somebody else and I've been set up.
Well, I think the inference is that he was guilty is because Hartfield sent that to both Blalock and Ryan. He didn't send it to anyone else. It was to them two specifically.
And did he ask afterwards, what did she say?
Yes, she did ask, what did she say? And so I think the obvious interest here is that we're still, and as I would put it, we're still in the concealment phase of the conspiracy here. And that she's asking about what happened. And this is closely short in time. There's no other evidence in the record of any other activities that could have incriminated him or them that happened after the shooting. And so the obvious inference here is that this related to Blalock's admission of guilt to his co-conspirator. If there's no other questions, I'll address the third enumeration.
Sure.
Of the text messages. Here we have the trial court found that there's deficient performance in failing to find the text messages. There are two text messages that were sent by Bernard Mitchell to a person with the Instagram handle PFK Don, and largely they both say we shot back. And while there was deficient performance in failing to find, the trial court found that there was no prejudice from them. There was no evidence that they would necessarily use them, and also importantly, that they were cumulative other evidence that had already been, in my words, debunked by Detective Hogan. And I'll just go ahead and go to the cumulative here, is that Mariah Smith had already she told law enforcement during her interview, and that came out with Detective Hogan's testimony, that she had told them that Mitchell had shot back. And when that was presented, Detective Hogan said this did not make sense with the physical evidence at the scene. In order for it to shoot back, they were talking about the 9mm shell casings that were found at building, I believe, X, and the two that were found on top of the car. And when he testified, he said 9mm shoot, and when they eject, shell casings, they eject up and to the right. So for someone to shoot back at someone at that angle, the shell casings would have landed away from the vehicle. They would have not landed on top.
It is true that not all handguns eject. I mean, revolvers don't, right? I mean, so the fact that you didn't find casings from a third gun doesn't mean there weren't a third gun, right?
Doesn't necessarily mean, and Mitchell and Uden both said they had guns, and Mitchell in particular said there's a 22. There's just no evidence of a 22 being fired there. And for the shell casings that were found, it was that Detective Hogan testified that a 22 does not shoot 9mm or 7.62 caliber bullets that were found at the scene.
Counsel, can you now address cumulative prejudice? Because I mean, I've heard you talk about 3 enumerations, and it seems like there may be deficiency with all of that, and you've gone to prejudice. So you've got prejudice from taking the fifth, you've got prejudice from commenting on silence, you've got prejudice apparently from admitting these text messages. How is that not cumulative enough to warrant a new trial?
I don't think these are cumulative enough because I don't think they actually impact the evidence that was given that supported the defendant's guilt here. None of them take out.
That's a tough argument.
It is a tough argument, but I don't believe that they pull out any of the pieces that would support defendant's guilt. It's not that you're removing, let's say, the Instagram messages that were circumstantial.
But all the evidence that you offered us to support the strength of the conviction was also circumstantial. So we're
Right.
pulling out, circumstantial building blocks in a circumstantial pyramid.
But they're not necessarily being pulled out here. The as we've talked about, the text messages, they were largely debunked anyway. The jury had already heard it's cumulative, so you're not pulling out any evidence there. The failure to testify, there's no evidence that what he would have testified. There's nothing that's being debunked there.
But the prejudice is the fact that you alluded that he should have testified and he would have not been able to provide any evidence other than, he was at the scene of the crime. I mean, that's the prejudice there.
But there's enough.
Is it possible that that prejudice is also compounded in this context by the Fifth Amendment issue? Because the jury has heard instructions, not with respect to his not testifying, but about inferences they can draw about somebody who doesn't testify.
No, I don't think that's necessarily done. I think here is with the inferences that were made, they were with reasonable trial strategy and that they supported the trial counsel's strategy here, that there was another person there. And so I don't think it benefits him at all. And I don't think it attacks that to any extent. If there are no further questions, I just ask you to confirm these convictions and sit down. Thank you.
Thank you, counsel. Thank you, counsel, for both sides for the fine argument. We'll try to have your decision as soon as possible. Thank you.
All right. They got their 20 minutes each, and that's it. If they use all the time, there's no rebuttal. And to my understanding, what happened in that trial was, well, the main witness pled the fifth over and over and over and over again, which is prejudicial in itself, but not necessarily enough to warrant a new trial, apparently. But Brian Steele argued masterfully that combined with these other issues, especially referencing the defendant's silence, now you have two things that the Supreme Court can take as, yeah, these are not reversible errors, or these might be unforced errors by the... I can't play North Media. I can't play again because this stream do not allow, the court stream do not allow me to go back. So this is it. If you want to hear it again, I will cut it. I will cut out his part and make a video out of it. Okay. And then the Supreme Court, they went to cumulative error. And then it's so Mr. Steele in his filings had three prongs. He argued two of them, and then the Supreme Court judges brought up the cumulative effect themselves. And he was allowed to argue a lot, not that many interruptions, which generally is a good sign. Now, the state's representative barely had time to say, hello, my name is, before he was interrupted. And when that happens, you're in for a ride. And I don't go his argument now before the Supreme Court, everybody gets nervous unless you're Brian Steele, who has argued before the Appellate Court and the Georgia Supreme Court over 200 times. And yeah, for me that is and also the lack of confidence in the state's argument. always is, well, not necessarily. And and he was showered with questions from the Georgia Supreme Court. Absolutely showered. And it, yeah, I agree with MG Law. He said, based solely on the state argument, since I missed Steele, I would expect a new trial to be granted. Yeah, I mean, first with the witness pleading the fifth, then the state bringing up the silence of the defendant. I forgot what the third prong was, and then the cumulative effect. Yes, I would suspect that Blalock gets a new trial. And if he gets a new trial, so should Lil Rod. Because they were co-defendant in that trial. Yeah, and the extremely bad instruction to just cut out 5 words from an instruction. Or from the state's argument in that instruction. That was really, really bad. But that was, I will cut out Mr. Steele's argument, make a video, and we can all rewatch that. But for me, excellent presentation by Mr. Steele. I would say it looks better than usual for the defense, for the appellant, Mr. Blalock, and by proxy, Mr. Lil Rod. I think it looks good. Because with proper representation, that and a retrial, yeah, we might see in a year or so the Lil Rod's retrial. Am I going to stream it? Yeah, I hope so. So, but we don't know yet. But listening to the Supreme Court judges, yeah, it seems a better chance than usual that they will reverse the conviction and send it back down to the Superior Court. That's my interpretation of it. Okay. Now I can address Harp City, $10. Thank you so much. Hi, Nick. I was watching your YSL trial. Mr. Adkins is questioning Miss Latner's. I can't stand how many times he says her name, so here I am. Thank you for covering this important case. I haven't watched any of today's YSL trial. I've heard a bunch about a juror contacting the judge. And yeah, today will be interesting. Today will be really interesting. Recap at 5 p.m. Eastern Standard Time. Carmela Allen Bennett, $5 super chat. Thank you so much. Thank you, Nick, for hosting this trial. Thank you for being here, and thank you for your support. And then Mahadi de Jesus gifted a membership. Thank you, thank you, thank you. Mr. Steele and Mrs. Steele have a law firm together. They work together and they do appeals work and trial work together or separately. So, yeah. Yes, Empress Fox. Brian is doing what he can for Lil Rod. Okay. Thank you all for tuning in. Me and Mr. Jingles. Thank you for being here. And I will see you all in just about 6 hours for the recap of today's YSL trial. Free Jack Gotti, free Shannon Stillwell. And folks, remember, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. All right? See you later. Bye-bye.